Welcome, my legal eagles, to the second video of preparing for the substantive topics for our upcoming tort law mock exam. So I'm going to go full screen here. I'm going to focus on psychiatric injury. I did think whether to include pure economic loss and negligent misstatement, but I'm going to deal with that separately rather than overcomplicate things. So one of the things you should be doing for your revision is rereading your notes and proactively trying to then condense them down, be it onto flashcards or one side of A4, or indeed, as I've done here, one slide. It makes it certainly more manageable and easier to learn and revise. Again, I know I'm going to say this probably every video, but the whole process of then looking at this, covering it up, rewriting it from memory, how accurate were you if you check again, and really it's that regular repetition of trying to do that. I know that some of you might have bought a whiteboard to do that, but you can equally just do it with a pen and paper. So for psychiatric injury, we start with the victim must have suffered a mental injury which has to be more than shock or grief. And of course, this has to be supported by medical evidence. Now, I'm just going to bracket the cases here. If you want to go any deeper into them, of course you can. Don't worry too much about the facts of the cases. What we want to get across as a starting point with any topic is just what is the key element, what is the case or legal authority that supports it, and that's what you've got here, largely, cases in brackets. If you can build on that and then feel that you can discuss your answer in more detail, perhaps when you apply it to a problem scenario, if you see a problem scenario that has a similar facts to a case that you've learnt, then of course you can do that and develop your analysis and evaluation marks, which for AQA is known as Assessment Objective 3. But anyway, I come back to this. So the first thing is the victim must have suffered a mental injury more than shock or grief supported by medical evidence. Really important. And Vernon and Bosley really just supports that. And it was where a woman witnessed, I think, firefighters trying to cut her children out of a car wreck, an accident she just got into, and she suffered from, naturally, shock. But that wasn't deemed enough. Now, at which point, with a problem scenario, you have to decide which category, if any, the claimant falls into. So firstly, we have primary victims, and then we're going to talk about secondary victims. Now, primary victims are a lot easier, and I put in brackets here, they are at risk and suffered mental injury at scene. So very clearly, they were in that proximity of danger, that zone of danger, in the accident, and if they've suffered a mental injury that can be supported by medical evidence, it will be a successful claim. And two examples you need to look out for is firstly a rescuer, which we can see in the Chadwick and British Rail case, and then secondly a near misser in the Delu and White case. Again, very briefly, I think the textbook makes some reference to rescuers, largely referring to professional rescuers now, like firefighters and so on. But nonetheless, if you see someone who is a rescuer in a problem scenario who was at risk and suffered mental injury as a result, then you should be flagging that up. A near misser in Delu and White, I believe that was where we had the lady. She was in a public house, and horse and cart came through the actual pub itself and narrowly missed her. So as a result, she suffered nervous shock and she was able to claim. We're going to look at an exam question shortly that I've created for primary, but a lot of the work really lies with the second one. If they're not a primary victim, if they're not in the zone of danger, then they have to claim as a secondary victim, which we've got here. So this means they've suffered mental injury, but they've done so after witnessing an accident or its immediate aftermath. They themselves were not in the zone of danger, i.e. at risk, but nonetheless they've suffered this mental injury, and if they're to be successful with their claim, they must pass the Alcock tests, of which there are 4. So I've laid them out here as well. So all 4 have to pass. The first is that there are close ties of love and affection between the claimant and the victim involved in the accident. Now, if it's a spouse, a partner, a family member, then you have I think a presumption from the court that is met. But again, evidence to support this would strengthen the claim. Secondly, that they suffered, the claimant, that mental injury at the scene or its immediate aftermath. And this is where we've got to be very mindful that what does immediate mean? So the law has tried to be fair here, and therefore one sort of, I should add in here actually, I didn't, did I? There we are, I'm adding it in now. One sudden, going back to full screen. Yeah, one sudden horrifying event, then up to 2 hours seems to be the time limit. So if the claimant, witnesses a negligent accident and they suffer a mental injury within a 2-hour period, then that would be satisfied. And that's the McLaughlin and O'Brien case. Again, there are instances, though, aren't there, where there can be a series of horrifying events, and it could be quite unfair, couldn't it, just to say 2 hours and then that's the cut-off point. So the law has kind of tried to be flexible with the North Glamorgan NHS Trust case by saying if there are a series of horrifying events, then it could very well be up to 36 hours if the person suffered that mental injury within that time. And again, just to explain, that case involved, I think, a mother who witnessed her young child in hospital suffering seizures and various other medical complications over a period of time before the child died. And so the law was accepting there that, although it passed 2 hours, within 36 hours to allow the claim seemed the fairest thing, and that's really where the precedents remained. Thirdly, that the claimant has witnessed the accident with their own unaided senses, and that again links in with the Alcock case where these tests come from, because that was, of course, the Hillsborough football stadium disaster. There were people who were watching the match live on television, or perhaps hearing on the radio, or whatever it may be, and the courts have said that no, you have to, if you're going to be a successful claim as a secondary victim, you have to have witnessed it, seen it or heard it yourself, not through the various things here. And then lastly, the threshold test, really for the court to determine, would a person of reasonable fortitude have suffered the mental injury. So we're saying here that the person is not, overly sensitive. So for a secondary victim, all 4 tests have to pass. The reason that they're doing this, remember, is so that they don't enable the floodgates to open to too many claims. Now, you might say that's unfair on the one hand, because indeed, what if someone suffers mental injury in the immediate aftermath and it's over 36 hours, or they do, witness an accident on television and suffer mental injury, they can't claim. So that would be unfair. But equally, as I said before, the positive would be, the courts do not want too many claims flooding the courts, and there has to be a cut-off point somewhere so that the most deserving are being heard. So now that I've done all the psychiatric injury on there, there are, of course, 1 or 2 additional cases that could be added that I haven't. But remember, this is about condensing it down into exactly what I need. Let's have a look at some exam questions. So I've written this one up earlier today. I'm going to call it a 10-mark question. Got an amateur magician called Max the Marvelous Mason is performing at a local theatre on a reality TV show in front of judges and a live audience, with the hope of being picked for the competition. Max's main stunt is a predicament trick where he is submerged in a large glass tank full of water on stage while wearing a straitjacket, chained to a weight at the bottom of the tank with a single padlock, and escapes before drowning. That's the trick. So Max performs the trick on stage and successfully frees himself from the straitjacket before examining the padlock. But after approximately a minute or so of struggling, he falls motionless. And another 30 seconds basically pass as the live audience and indeed the judges think that's part of Max's act. But when it dawns on them that it isn't and something horribly has gone wrong, the audience become distressed. Now, one member of the audience, Jessica, 10 years of age, begins to cry and suffers nervous shock as the stage assistants retrieve Max from the water tank and begin to resuscitate him. Mira, watching events unfold live on the television, also suffers nervous shock as the camera cuts away and it's clear that the magic trick has gone wrong. Now, thankfully, Max's life is saved, and a later investigation uncovers that one of Max's assistants left the key to the padlock in their room instead of giving it to Max. So the question is, discuss the rights and remedies of Jessica and Mira for the incident with Max's magic trick. So as before, what we're going to do is, and you can follow along as well or pause the video, we are going to plan an answer to this. So I've got a spare slide here. I'm just going to try and minimize it as best I can. First thing to note, though this is a 10-mark question, any of these substantive topics can of course be 30 marks questions, and it's worth remembering for psychiatric injury that it's often partnered with basic negligence in a 30 marker. The reason being, you cannot have a claim of psychiatric injury unless you have negligence. So the person you're suing, you're saying has negligently caused your mental injury rather than a physical one. Now this question, we can also say, we'll go through it now. So highlighter pens out. I think the first thing you're looking for is some kind of mental injury. So that was the first thing I had on my slide, more than mere shock and grief. So as we're talking about Jessica and Mira, let's start with Jessica first. So Jessica, 10 years of age, suffers nervous shock. So I'm going to highlight that. Just 1 second. There we go. Don't think it matters the colour too much. Let's pop it into green. So it's these words here, nervous shock, that if I put in bold, is a sort of catch-all term for a mental injury. You could find in an exam question, problem scenario, that it refers to it as something else. So rather than nervous shock, it could be, depression, post-traumatic stress disorder, the list goes on, but you might see it just referred to as nervous shock. I think we'll deal with one at a time would be best. So again, back on my thing here, expanding it out, and you should be able to download this after the video. So we said here, C must have suffered from a mental injury, and what I want to put here is Jessica has, there we are. Jessica has suffered from nervous shock, and then we want to say, so she suffered from nervous shock. We'll need medical evidence. That's what we said earlier. So you must have suffered from nervous shock with medical evidence supporting. So that's the first part, and then obviously the second part is, when we go back to Jessica, is she a primary victim, first of all? Now, as she's a member of the audience and would appear far removed from any sort of zone of danger, or, she's not at risk herself, then she can only claim as a secondary victim. Now, what I would do, particularly if it was a 30-mark question, I'm going to do it anyway, is I would in my answer define what a primary V and a secondary V are. So that would be my starting point to develop my, knowledge and understanding marks. That's my assessment objective 1 for AQA exam. And then you've got to decide which one it is, which we just did. So we could go on to say AO2 equals AO2 assessment objective 2. That's me applying it now. Jessica is a secondary victim as she was in the live audience watching Max's magic trick and was not at risk herself. Okay, therefore she will need to pass the 4 we mentioned earlier Alcock tests. Okay, so we're going to have to lay them out here again, aren't we? So again, do it from memory. C has close ties of love and affection with V. In terms of application here, I think you would have to say no, because it's not, Max the Marvelous Mason, the amateur magician, he's not a family member, he's not a loved one. So on face value, it would look like this test would fail. So this test is likely to fail as Max, the magician, is not a family member or loved one. Now again, you could say that's a bit harsh considering that Jessica's been left with a mental injury, this nervous shock, but again, we discussed the reason being is these claims for secondary victims are quite strict for the reasons of not allowing the floodgates opening to too many claims. Now, even though this looks immediately to me and to you that this claim is going to fail because all 4 tests need to pass and it looks like the first one hasn't, we're going to continue anyway, as we would in our answer, to discuss and apply the others and get those marks. So the other part was suffered a mental injury at the scene or in the immediate aftermath. Okay, and we have a look again. There's no sort of specific indication as to time. It looks like as soon as she's witnessing the distressing visual of the magic trick going wrong and the assistants running on stage to resuscitate him, get him out and resuscitate him, that it looks like it's quite sudden, doesn't it? So I'm going to put here Jessica in witnessing Max's magic trick going wrong and him being resuscitated. Oh, make sure spelling's correct. Resuscitated on stage. This is a sudden and horrifying event. So, in other words, what we're saying, within 2 hours. So this sudden horrifying event, and Jessica has suffered nervous shock within 2 hour limit, and that's where we would refer to, I think we said earlier, didn't we, McLaughlin and O'Brien. So again, I'm just going to put it in brackets. Number 3, through C's own unaided senses. So remember, Jessica can't have, I'm just realising that I wanted to lay this out a little bit similarly, so I'm going to put here apologies. It's just me being pedantic, but there we are. AO2 equals, there we go. So yeah, through C's own unaided senses. So did she see it herself, hear it herself? Wasn't through, you know, television, radio, someone else telling her about it later, etc., or social media post. And clearly that's the case here. She's in the audience. So we're just going to put AO2 equals Jessica witnessed the accident herself as she was in the live audience. I think that's enough. And then lastly we had the threshold test, which was, would a person of reasonable fortitude have suffered the mental injury? And this is really a question for the court and a question for us. We have to give an opinion, although we may potentially differ. I think because the first test fails, it's a clear-cut thing. But I'm going to put here finally AO2 equals. I think the test, yeah, with a reasonable fortitude. Is she overly sensitive? She's 10 years of age. No. So I think no. It's reasonably foreseeable that a 10-year-old would become distressed having witnessed the live accident and suffered nervous shock. So if I zoom that in a bit so we can have another look, this is my plan so far. So must have suffered from mental injury. Jessica has suffered from nervous shock. Again, if I just want to make sure I'm following what my plan said, so it's making sense, I should just put AO2. It's the same thing, isn't it? But there we are. Is that better? So AO2, the application equals Jessica has suffered from nervous shock. That's the bit we highlight. Then for the marks, we define what a primary victim and secondary victim are, but we then have to apply it and decide that she is indeed Jessica, a secondary victim, as she was in the live audience watching Max's magic trick, was not at risk herself, so she'll need to pass the 4 Alcott tests. We've got them labelled down here, and basically what we've said is the first test fails, the subsequent tests 2 to 4 pass, but because not all 4 do, the claim is going to likely fail. And I think what I'll do on a separate slide is deal with the remaining part of the question, which was Mira. So if we have another quick look, Mira, you'll remember, there we go, was watching events unfold live on the television when she indeed suffers nervous shock as the camera cuts away. So I'm going to highlight that for a minute. And I'll pop that one into yellow. Okay. So we can see that there. We're now dealing with Mira. And I think if you've been following along, the answer gives itself away a bit. So again, when I write my answer, I'm going to start by dealing with this. So let's pop it back in. I could deal with it at the same time if I wanted. So basically what I'm saying is when you're answering this question, you could deal with Jessica first and then Mira, or you could deal with them as you outline each element at the same time. It is entirely up to you, as long as you've explained the law, that slide from earlier that condenses everything down, the AO1 knowledge, and you apply it to both. So here, if we do it then, I could just put something like AO2 equals Mira has suffered, it's the same thing, isn't it, from nervous shock. And then, again, didn't we say primary or secondary victim? We have to say what that is. So that's where our answer is taking us. We've already dealt with Jessica, but this time we're dealing with Mira. So Mira is, excuse me, I better put AO2 again. There we are, make it clear. Mira is a secondary V, as she was not at risk, in the zone of danger, but witnessed the accident or its immediate aftermath. Okay. At which point, you know, again, must pass all 4 Alcock tests that we said earlier. And what I'm going to do here is just copy and paste it, because I'm save myself some time. And now all we're doing is applying them to Mira. So in it goes. I'm just going to cut out the bits for the moment relating to Jessica, because we did her earlier. Oh, I think I'm going to need some editing here. I'll do it as I talk to you. So where are we? We've said Mira is a secondary victim. Alcock tests. Firstly, claimant has close ties of love and affection with V. So again, this is going to fail, isn't it? No, as Mira, or rather as Max is not a loved one or family member to Mira. So that should be the same as what we said before. Yeah, I put this test is likely to fail. I'm putting no here. It's the same thing. Secondly, suffered a mental injury at the scene or in the immediate aftermath. So again, for AO2 here, we're going to put Mira suffered nervous shock at the scene. Well, we'll get there. It's the next bit, isn't it? That's the problem as well. Through Mira's own unaided senses. Well, this test is going to fail, isn't it? No, this test will fail as she watched it on the television. Again, at this point, I would still be laying out the threshold test. Is it reasonably foreseeable? You know, would a person of reasonable fortitude have suffered the mental injury? Again, it probably doesn't matter at this point so much, because the other 2 tests for Mira failed, number 1 and number 3. So this is your opinion. You know what? I think it could arguably reasonably foreseeable that, we don't know the age, but she's presumably an adult. No, it's reasonably foreseeable that Mira would suffer nervous shock after witnessing the accident. I've done too many S's there, haven't I? That doesn't look right. Witnessing. Okay. So, yeah, just to recap then, this is still one answer. So, if we do it by answering it running alongside each other, we started with the claimant must have suffered from a mental injury with medical evidence supporting, or Jessica's got nervous shock, Mira's got nervous shock. Then we define what primary victim and secondary victim are for AO1 marks. Then we apply it. We've done this on the previous slide to Jessica. Now we're doing it with Mira. So you could just, you know, mention that directly afterwards. She is as well needing to have to claim as a secondary victim. She witnessed the accident, therefore has to pass all the Alcock tests. So that's the same thing as indeed Jessica. On the previous slide for Jessica, we outlined those 4 tests. And again, if I was writing an answer, I could apply the answer to Jessica and then apply it to Mira for one of the first tests, then go to the second test, apply it to Jessica, apply it to Mira, and so on till I get to the end of my answer. And what we're saying finally here for Mira is she fails test 1 like Jessica, but she does also fail test 3 because she's watched it on the television. Okay, so this I'm going to save, and this will be one of the handouts. This is my answer plan for that. Just very briefly, oh, sorry, forgive me. Remedies. I nearly didn't do that. So the question does say remedies. We've been dealing with whether in law Jessica and Mira have the right, you know, to sue. But in terms of remedies, even though it looks like both claims are going to fail, I would always in my answer put something like, however, if successful, Jessica and Mira can claim damages for their mental injury, i.e. compensation. Now, we may very well do a later video on remedies. The main thing is you've linked it to the type, but what I would say is if you wanted to go into more detail, and we will look at this at a later video, you'll remember that there is a claim for general damages or special damages, and so things like costs for medical treatment, medical bills, there could be a claim there. There could be a claim for loss of amenity in terms of how their life's been affected, both Jessica and Mira, since this. But seeing as this is just a 10-mark question, I think just saying damages, if successful, would be enough. Okay? But finally, what I was going to say is I've also done another exam question I wrote up today. I'm going to show you now, because I think you ought to also have a practice at primary victims. So here is my primary victim one. Again, 10 marks. Sometimes people feel, even in a 30 marks question or a 10 marks question, they feel, oh, it's a primary victim, I don't write as much as I normally would as it would be for a secondary victim, and sometimes they can make the mistake of second guessing themselves and thinking, oh, it must be secondary if it's worth 10 marks, why would they ask me about primary? Well, of course they can. Alright, so let's have a quick look at this one. Barry is returning home late one night from the pub when he witnesses a speeding car pass him and go through a red light into oncoming traffic, crashing into another vehicle before both come to a rest on the road. Barry runs towards the two car wrecks and sees the speeding driver is lying unconscious at the wheel, whereas in the other vehicle an apparent mother and her young daughter are in distress. Barry prizes the car door open and carries the young child out, then the mother, before turning his attention to the unconscious driver. Smelling petrol fumes, Barry becomes further concerned and quickly opens the car door before dragging the driver out to the side of the road. And just as he does that, the vehicle explodes into a ball of flames. Barry is later assessed by a medical practitioner as having post-traumatic stress disorder, PTSD, due to the incident. And again, question, discuss the rights and remedies of Barry for the incident with the automobile accident, I should say. So for this week, I would like you to write an answer, please, to the first question we've gone through together for secondary victims, that 10 marker. So write me a full answer to that, please. And just to cover the bases, I need you to write as well one for this Barry question. Now this one will be a lot easier because, as you can see, yeah, and let's just highlight the right bits. We know before, don't we, that the first thing you're looking for is, has Barry suffered a mental injury? So of course, highlighter pen's out. There we go. Let's highlight that in, let's do it in pink this time. See there, post-traumatic stress disorder. That's what we're looking for. So we're going to start by referencing that. Secondly, your answer is going to again explain what is a primary victim compared to a secondary victim. But this time, for your application AO2, this is a primary victim. And I think what we're saying here is smelling petrol fumes, he becomes quickly concerned, and then it's really, I suppose, this last bit that I wrote, isn't it? Again, I put it in a colour. Let's put it in that colour. Barry is at the scene and he is at risk. He's in the zone of danger because he runs towards the wreck. He's smelling petrol fumes, and basically the fear is the car could ignite and explode, and that is of course what happens just after he drags the unconscious driver, the unconscious negligent driver who caused the accident, onto the side of the road. So this is a primary victim, and we're going to say, as I just said, why, but also you've got opportunity here to discuss and label Barry as a rescuer and explain why, and of course the case that we bracketed, and finally as a near misser, because of course really it's only within perhaps a few seconds of dragging the driver who's unconscious away, that the car explodes, and that could have exploded and seriously injured or indeed killed Barry. So that means we can talk about rescuer and near misser. And then of course we would finish your answer by dealing with the remedies part, which would be, just very simply for now, that Barry could claim for damages, but we'll again cover that in a future video. I hope that's been useful. I went into a little bit more detail. I don't want to talk too much more. I'm going to end this now, so please write out those 2 answers and submit them as your study plus for this coming week. Thank you very much, everyone.